Good evening and welcome to all of you in today's webinar on navigating the aftermath, analyzing the Supreme Court's decision on Most Favored Nation clause. Today, we have the distinguished presence of CA Piyush Chhatar Sir, Vice Chairman of Direct Taxes Committee. With this, we have CA Sachin Sinha Sir, who is fellow member of ICI having 20 years of experience of domestic and international taxation and management consultancy. Sir has deliberated many webinars and seminars at various forums and is visiting faculty of ICI for Diploma of International Taxation and Certificate course on UAE's corporate tax. Sir will be the moderator for today's webinar and will give us an overview of Supreme Court case study and also will take us to Q&A in the last of the webinar. Along with this, we have the esteemed presence of Shri S.P. Singh Sir, who was with the Indian Revenue Service for more than 2 decades. He held various positions, including Director of Income Tax International Taxation and Commissioner of Income Tax Appeals. He participated in negotiation of tax treaties with more than 30 countries and took part in mutual agreement procedures. Today, Sir will be giving us the overview of Most Favored Nation clause. We have the distinguished presence of CA Pramod Kumar Sir, the speaker for today's webinar, who is former Vice President of Income Tax Appellate Tribunal, Mumbai. He joined as a member of Income Tax Appellate Tribunal in the year 2000 in Kolkata and later has been posted in its several benches. In his more than 2 decades of long judicial career, Sir has written around 15,000 renowned judgments on various facets of income tax law, which includes transfer pricing and international taxation. Sir has also worked on the United Nations South Sharing of Successful Tax Practices project and has delivered talks in several conferences, webinars, and training programs in India and abroad. With this, I request C. Piyush Chhatar Sir for his welcome address for today's webinar.
Thank you very much, Prachi, the honorable speaker for the day, CA Pramod Kumarji. I would address him as a CA because he's a chartered accountant. Obviously, a vice president. He was a former vice president of Income Tax Appellate Tribunal. I've appeared before him, and a lot of practicing chartered accountants in last 25 years who have developed themselves would always look forward to him when he was sitting on the bench, because it was always very motivating to appear before him always. SP Singh Saab, thank you very much once again. The former IRS, he's always available for DTC for this year. I think so your contribution has been always immense. Thank you very much again for giving this overview on this very important topic. Sachin ji, who would be moderating these sessions, a warm welcome to all of you. And a very good evening to all the participants who are there. Again, warm welcome to all of you. This year, Direct Tax Committee, I will just brief you once again for the benefit of all the members. This year, Direct Tax Committee and International Tax Committee have been merged. Hitherto, both the committees were different. There was two committees as far as institute is concerned. One was Direct Tax Committee, one was International Tax Committee. This year, both the committees have been merged. I am addressing you. I am giving my opening remarks as a substitute to my chairman, Sanjay Agarwal ji, who was supposed to give, and I was supposed to give concluding remarks. But due to some unavoidable circumstances, he is not available. So he will come to give the concluding remarks. He will be there. He will be joining us by 5:30, 5:40, I believe. So as far as Direct Tax Committee, after the merger, we have been doing a lot of work on it. 3-4 important aspects which I would like to touch before we go to the session is the technical guide on audit report of 12A registered units. You know the audit reports had come, 10B, 10BB. We had 3 to 4 continuous sessions with the speakers. More than 300 questions were resolved at that moment of time. That technical guide has already come. In the last committee, we have decided to convert that technical guide into a guidance note. As you may know that the publications is issued by the ICI carry certain amount of whether they are mandatory or recommendatory. Technical guides were recommendatory in nature, and therefore we want to move it forward to make it as a guidance note. So though it may remain a recommendatory even after becoming a guidance note, but it will be at an higher pedestal, whereby it is in a way a mandatory in a nature, because if you are not complying with the guidance note, then you have to be sure about the documentation and why the reasons should be with you, why you are not complying with those particular guidance notes. So that's the one area which we will be working after the issuance of technical guide. We are converting those into a guidance note. Second area, which for next 3 months, which we have targeted is revision, making a suggestions on revisions in Form 3CD. We have made a white paper on it. What should be the changes we made in Form 3CD as a proactive measure, and will be presenting shortly in the month of December to the tax policy department of CBDT, basically with an idea that there may be a lot of particular clauses in Form 3CD which may be redundant today. And there will be a lot of amendments which have taken place in last 3 to 4 years, which may be incorporated in the Form 3CD. So with these suggestions, we'll be going to them. Last week, when we had a direct tax committee, we have also approved a pre-budget memorandum, which will be presented to the CBDT in the month of December. So these are the 2 or 3 important areas which we are working. The revision on guidance note of tax audit also took place, which was well received by a lot of the members, and it was available online also. All our publications are available online. As far as this webinar series is concerned, we are continuously holding this webinar every fortnightly. One fortnight we try to cover international tax issues, and another fortnight we try to cover issues on the direct tax. So this is with an idea. The most important thing, one more thing which I would like to again brief is about the tax clinics, a successful tax clinic which we had this year on 13th and 14th of July, a tax clinic to increase the tax awareness amongst the individual taxpayers. It was held at 164 branches, and it was attended by the revenue department officers who visited our branches and tried to help the people who were facing any difficulty in the filing of the returns. So these are the 4 or 5 major activities which GTC was doing and would be doing further also. Coming to today's session is, as it talks, the headlines, navigating the aftermath, analyzing the Supreme Court's decision on most favored nation clause, MFN clause, as we know. And I know the speaker, none other than Shri Pramod Kumarji. I think so nothing can be better than that. He has, to his credit, a lot of laurels, a lot of judgments on the international taxation from a Mumbai tribunal when he was there. He was there in Delhi, Ahmedabad, a lot of time also. I'm sure the speaker and the other speakers, Singh and the moderator, would be discussing the aftermath of the Supreme Court judgment, the implications of the judgment, whom it should be available, the benefit of MFN clause should be available, whom it should be available, when it should be available, what process should be completed for application of the MFN clause. So I believe these 2 hours next would be quite interesting. So I welcome you all once again, and thank you very much to all the speakers for acceding to our request for addressing on this webinar. Thank you very much. I would now request, I think so, moderator Sachinji, if you can take the forward discussion ahead. Thank you very much.
If sir will be taking over and giving us the overview of MFN clause.
Okay.
Sir, over.
Yeah.
Thank you.
Sure.
Thanks, Piyushji, for setting the tone. But before actual discussion, I would like to thank the Direct Access Committee of ICAI for organizing this webcast on a topic which has attracted attention in India as well as outside India by everyone interested in taxation. It's a very recent decision of the Honorable Supreme Court in the case of Messrs. Nestle. This decision is a landmark decision not only on the most favored nation clause, which we call, on the basic understanding of the interpretation of tax treaties. No doubt, this is the core topic of this webcast. However, the panel will also discuss a few more topics which have wider ramification and may be of interest to all the listeners to these webcasts. We are privileged, as mentioned by Piyushji, we are privileged to have Pramodji on the panel, who does not need any introduction. He is one of the most well-known and highly respected expert on taxation. His willingness to address his students of international taxation as well as the wider varieties of tax, simplifying complex topics is the hallmark of his discourse. He has, as Piyush just mentioned, written a large number of decisions on very complex issues when he was member of ITAT. All these are legendary. He will share his thoughts on the decision of the Supreme Court. He will also be sharing his thoughts on some of the fundamental facts regarding two important sections, that is section 149 and 201. He may not be going in much detail looking at the time, but he will highlight some of the features which is important for all of us. I would like to thank Sachin, a young, dynamic, and highly acclaimed expert on taxation, who will give us the overview of the cases on MFN clause. Friends, in order to appreciate the decision of the Honorable Supreme Court, it is important to understand a few basic facts which must be coming in your mind. The first is, what is MFN? Why is it required in the first place? Third, why is it in news? And finally, why should I be interested in knowing MFN clause? We, the panelists, will try to cover these four issues while decluttering or while demystifying the issues around around MFN clause. Let us first look at the rationale of having the MFN clause in a tax treaty. Why is it there? What is the need of having MFN clause in the tax treaty in the first place? To know this, or to understand, or to have a view on this, one needs to remember that a tax treaty does not only avoid double taxation. It's a very minuscule aim of a tax treaty. The most important is it makes breeze between two differing tax systems. Along with that, it provides platform for the tax authorities of two countries to assist one another in effective implementation of the provisions in the tax treaty, as well as their domestic tax laws also, to a large extent. While negotiating a tax treaty, the authorities, on the one hand, try to ensure the best possible tax regime for their investors, as well as the people interested in investing in their countries. This on the one hand. On the other hand, they seek to safeguard their respective interests and ensure, which is very important, and ensure that the terms proposed in the treaty are not less favorable as compared to those provided or likely to be provided to their competitors. No country wants to be left behind in any opportunity of investing in a growing market. The competitive level playing field is sought to be achieved by incorporating an understanding in a protocol or exchange of letter, which forms integral part of the tax treaty. This extension or safeguarding of benefits is achieved through the famous most favored nation clause. In other words, the objective of the most favored nation clause or MFN clause in a bilateral treaty is to ensure that the contracting state is not treated less favorably than any other state under similar contract which the first state will be entering into. What I mean to say is that suppose India is negotiating a treaty with country A. Now, the person negotiating on behalf of country A will like to have a regime or like to have the provision or tax regime for its people, which should not be less favorable than the countries which are its competitors. And this is why you must be observing that this clause is there in the tax treaties of India with the OECD countries. In other words, MFN is one step ahead of non-discrimination clause. The non-discrimination ensures that the citizens of a treaty country is not treated less favorable to to the citizens of the source state. This goes one step ahead. It tries to ensure that particular tax treaty is entering into a contract with any other country which is on the same level of development or is a competitor to it. Obviously, the MFN clause is to boost economic relations between the two countries. Normally, MFN clause may not apply to all streams of income, and it is confined to defined income. It doesn't cover business income. It doesn't cover shipping or airline business. It covers very specified income, and depending upon the nature of clause which are in negotiate. So the language used in the MFN clause is very, very important. Further, all countries do not subscribe to inclusion of the MFN clause in their tax treaties. In fact, my experience is that it's the developing countries which are keen to provide the MFN clause in order to attract investments from not only from one country, but from a host of countries. It is also interesting to note that the MFN clause doesn't find mention in the OECD module, but it is there in the UN manual for the negotiation of bilateral tax treaties between developed and developing countries, which is very obvious because it is the developing countries' interest to have a regime where there is, you can say, same level of treatment given to investors from multiple countries. It is very important for all of you to go through what is written in the UN manual, how it is to be implemented. Now it says for your information, I will read one paragraph and underline the most important factors which go in that paragraph. It advises, UN advises, that if two countries agree to include a most favored nation clause in a treaty, they should make it clear. In fact, they're supposed to make three things very, very clear. One, when that clause will be triggered. That is, at the time of signature or entry into force of another treaty, when the provisions of the other treaty will become effective. Remember, there are three countries involved in an MFN clause: source country, a negotiating country, and there is a country which is outside or of this, whose terms are going to be incorporated in the treaty being negotiated. Second, when that clause will have effect. And third, what will be the effect of the clause? Because the clause can be limited only to the rate or the benefit in respect of the rate, or it can be in respect of the scope of a particular article in the treaty. These are the most important things which has to be kept in mind while drafting any MFN clause incorporating in the tax treaty. The MFN clause normally seeks to extend a lower rate of taxation in respect of dividend, interest, fee for technical services, and royalty. And as I mentioned earlier, it is not extended to all countries. It is not a policy applicable to each and every country, but it is very limited to a select group of countries to which this benefit is given. The MFN clause in the India's tax treaty form part of the protocol or exchange of later to the tax treaties. Treaties of some of the OECD member states, such as the Netherlands, France, the Swiss Confederation, Sweden, Spain, and Hungary contain the MFN clause with varying scope and are in the protocol to the respective treaties. MFN clause in the treaties of these states inter alia provide that if India enters into a tax treaty with another country in the same block, you can say, or the same level of economic development, and grant any beneficial treatment in that treaty, then the same beneficial provisions will be extended to these countries. The issue regarding entities to which and when the MFN clause would be available have been matter of debate and have been matter of litigation in India. In order to explain the position of India, the CBDT issued a circular on 3rd February 2022 seeking to clarify. There are several things which were clarified in that circular. The most interesting was that it said that any unilateral decree or bulletin or publication issued by the other country will not be binding on India. Now, why was this? This was triggered by the fact that some of the countries tried to incorporate or came out with a publication where they explained that certain rates or certain terms contained in tax treaties with other country will be available from the date the other country came into OECD fold. So this is something which the government of India, the CBDT, didn't appreciate and which was highlighted in the circular. The circular went on to clarify the position of India regarding the applicability of the MFN clause. And the most important observation was that the MFN clause, the third country must be a member of the OECD both at the time of the conclusion of the treaty with India as well as the time of applicability of MFN clause. What does it mean? So it means that suppose the treaty between mentions the MFN clause that if India enters into a treaty with OECD member countries, then the benefit in that treaty will be available to the residents of France. Now the question is when. The CBDT clarified that this benefit will be available only if that third country was member of OECD when the tax treaty with France was entered into. And that's a very, very significant observation, which altered most of the position which general public or the advisors and all of us had been holding. It's a very, very important. It's very important to understand because protocol is not a separate piece of paper. It's very important. It is part of the tax treaty. And one understands and is able to implement only if the person reads the protocol along with the other provisions in the tax treaty. And therefore, it's very important that if there is MFN clause, then that has to be read very closely. So the dispute regarding the applicability, the time, the scope have been matter of litigation in India. And before I request Pramod Kumarji to analyze and demystify the decision of the Honorable Supreme Court and share his views, as I mentioned, in respect of Section 149 and 201 of the Act, I would request Sachin to give us an overview of some of the important judicial pronouncements on the MFN clause. Over to you, Sachin.
Am I audible, sir?
Yes. Yeah, you are audible. Fully audible.
So thank you so much, sir, for giving me this opportunity, and thank you for your kind words, and you have broadly explained the understanding about the MFN clause, because this is the core of the case. And if we understand as a practitioner or as a beginners of international taxation, if we understand the meaning or the application of MFN clause, then we can understand the whole case. So before I proceed, good evening to all dignitaries, senior members, office bearers, and learned speakers. I'm very much thankful to the DTC of ICI for giving me this opportunity to moderate this important session. So, as Sir has mentioned, my job is to give a brief summary of this judgment and the technical discussion. For the technical discussion, we have SP Sir and Pramod Sir. So, of course, we'll come back for the questions and what the participants has raised and or they will raise during the session. So if I talk about the summary of this case, it is very important and a landmark judgment both for practice as well as academics, where the Honorable Supreme Court took the reverse view of what the Honorable High Court has taken, either in case of Steria, Concentrix, or Optum case. This was the revenue's appeal, and in this case, the appeal arises from the decision of the Delhi High Court involving interpretation of the MFN clause contained in various Indian treaties, as Sir has mentioned, with countries that are member of the OECD. The treaties in question are between India, Netherlands, India, France, and India, Switzerland. So broadly, the issue arises whether there is any right to invoke the MFN clause when the third country with which India has entered into a DTAA was not an OECD member at the time of entering into such DTAA, and secondly, whether the MFN clause is to give an effect automatically or if it is to be only come into effect after the notification is issued. So these two are the core of this case on which the whole case has run and considered various judgments and sections in between. So in case of Steria India, the SSC challenges the order of the AAR before the Honorable High Court and contended that having regard to clause 7 of the protocol of the India France treaty, so protocol of India France DTAA, the more restrictive definition of the expression fees for technical services appearing in the India UK DTAA must be read as forming part of the India France DTAA as well. The AAR ruled out that the protocol could not be treated as forming part of the DTAA itself. So whole case started from here, and the High Court reversed the order of the AAR and accepted Steria's contention and held that the protocol is considered as a part of treaty itself and does not have to be separately notified for the purposes of application of the MFN clause. So it is also interesting to understanding the series of dates given in the DTAA, such as the signing of treaty date of entry into force, date of applicability of MFN clause, etc. Further, the Optum and Concentrix case were started when the department allowed the tax to be deducted at the rate of 10% and not as per the MFN clause. The SSC contended that the provision of the DTAA and the protocol, the revenue is obliged to extend the lower rate as per 5%. It is argued that since India has entered into DTAA with other countries which are member of OECD, the lower rate or restricted scope of the DTAA executed between India and such a country automatically applied. So this is important, automatically applied to the India Netherlands DTAA. This was based on the provision made in the preface of the protocol, which says that the protocol shall form an integral part of the convention. So it is already mentioned in the protocol itself, which says that this protocol shall be the integral part of this convention. So the important question which arises at this juncture, that as a method of interpretation, how the event, that is, the country is a OECD member and later entered into DTAA with India. Second, the country has had a treaty with India and subsequently become the member of OECD. So this is important, and I feel that sir will cover definitely in his deliberation that how this is to be interpreted and tested. So the revenue started the discussion by giving the reference of article of the Constitution of India. The learned ASG also discussed the Azadi Bachao Andolan, Section 90 of the Income Tax Act for the issuance of notification. He also submitted that without the benefit of any notification, any tax administrator, an assessing officer, or revenue authority would find it hard to verify the claim of any SSE. Of course, the sir has given the reference of 3rd February 2022 notification, and I don't understand that why, for the purpose of giving the administrative authority to apply this MFN clause, the notification is required, and unless the notification is issued, the benefits cannot be passed or given to the SSE. So this is important. Of course, I'll request sir to cover this in his detailed deliberation. So during the course, the learned ASG also discussed the Article 31 of VCLT, and the reference of course Section 4 and Section 5 of the Income Tax Act were also discussed. So the SSE contended that as per the DTAA, the relevant clause of protocol says this MFN clause is to be applied automatically, and in some treaty such as India-Philippines DTAA, which requires the countries to inform each other and review the provision with a view to extend the beneficial provisions. It means if you see, if you refer in some treaties, it is mentioned that automatically applied, and in some cases it says that it will be after the discussion. So does it have different application, or in all cases, even though it is mentioned that the automatically applied, or it is the discussion is required in both, in all the cases the notification is required. So the MFN clause simply states that the reduced rate as extended to an OECD country shall also apply. Shall also apply. So if it is based on the notification, then it can be said may apply subject to this, but it is not there. It says shall also apply. Or can we, for the purpose of interpretation, can we read this shall as may, because it is not shall per se for as the meaning that it will give the right to the SSE. So under this contention, under this current convention, and hence such clause is automatic in operation. So in respect of the term, now come to the second part. In respect of the term is, so council submitted that word is appearing in Article 10(1) of the India-Netherlands DTAA is in fact a complete answer to the revenues objection that Slovenia, Lithuania, Colombia ought to member of the OECD both at the time of signing of India-Netherlands DTAA and also at the time of claiming of the lower tax. So it is saying that is means both at the time of signing of agreement and at the time of claiming of withholding tax exemption. So the Honorable Court has taken the view that that notification under Section 90 under bracket 1 is necessary and mandatory condition for a court, authority, or tribunal to give effect of a DTAA or any protocol changing its terms or conditions which has the effect of altering the existing provision of the law. So the interpretation of the expression is having a great significance. The relevant date is entering into treaty with India and not later date. So when after entering into DTAA with India, such country becomes an OECD member in terms of India's practice. So the following, so considering this, the following important question which arises that whether the effect of this judgment is retrospective or so this is actually I wanted to understand from sir. So of course I'll present some questions when we come to the question answer session. So this is all from my side, and just an overview about the case. So thank you, and now we can come to Pramod sir for the detailed deliberation.
Thank you, Sachin. Thank you, Singh sir. Thank you, Piyush ji, for very kind words and for setting the tone for today's discussion. The first time I had an occasion to deal with the functioning of the MFN clause was way back in December 2001 when I wrote my judgment in the case of ITC Limited, a judgment which was later quoted with approval by their lordships of Honorable Delhi High Court. And just till about a year before my retirement, I was still dealing with this. I wrote a judgment called SCA Hygiene, which was referred in Honorable Supreme Court's judgment very kindly. And a year after my retirement, I'm still talking about it. Probably it gives a good idea that 25 long years are not good enough for something to reach finality in the judicial system that we have in our country. Very sad for the ease of doing business, but unfortunately, people like me who are watching keep their kitchen fires burning. I would, before, and you know what has happened suddenly, that law which seemed settled for almost a quarter century was unsettled. I wouldn't say unsettled, which was required to be taken another look by Honorable Supreme Court. Something must have happened so as to trigger this debate so late, and of course the judgment. Before I come to all this, let me quickly take you through how does the MFN work, what is an MFN, what are the background facts about this. SP Singh Saab, who is himself a treaty negotiator, who was a treaty negotiator for a long time, and who I understand was also dealing with Indo-French treaty in his days in the CBDT. He has already explained, but just for the sake of convenience and coherence, let me take another look at what does MFN do, what's its background, how does it work, and as I understand, many of you are not from international tax background, as to how you can easily understand and imbibe the concept. Typically, that if that is the tax jurisdiction, provides any concession to anyone in the parity group, the expression parity group, I'll explain a little later. But what it says is that if I give a concession to anyone in the parity group from the source taxation rule, the same concession will also be extended to the treaty partner. The parity group is generally OECD membership. I mean, that's a benchmark we use. That look, I'm giving it to, if I give it to any other OECD member, I would as well give it to you also. Now, to give an example, India has entered into a tax treaty with Hungary, which provides for 10% source taxation of interest income, dividend income, FTS sourced from Hungary, and vice versa. But it also says that in respect of Article so and so, so and so, and so and so, if India enters into an agreement with a third state, which is a member of the OECD, and India limits its taxation at source on dividend, interest, royalties, and FTS, etc., the same rate or scope as provided in that convention shall also apply under this convention. So it's like saying that I have given this, I'm agreeing to this rate with you. For example, a source taxation of FTS at the rate of 10% or 20%. But if I give concession to anyone else in that parity group, I will also extend that concession to you. Now, this concession could be in three ways. When we talk about the MFN clause, all MFN clauses are not homogeneous. They are not the same kind of MFN clauses. These are different kind of MFN clauses. For example, one clause, and which is what has come up in discussion in this particular judgment, that is what you call self-operational clause, as it was found in Justice Muralidhar's judgment in the case of Wisteria. It was a self-operational clause in the sense that concession extended to anyone in the parity group gets extended to treaty partner as well. When I use the word self-operational, that is not the expression used in the treaty, but that certainly indicates that nothing further other than the trigger. And what is the trigger? Trigger is if I give this concession to somebody else is stipulated in the scheme of the protocol and the treaty. That's category one. Category two is when on one or more aspect, MFN only triggers further negotiations without further delay. So what happens in this case is, if I give this concession to somebody, then we will negotiate as to how this concession is to be given to you also. There can be some situations, for example, in Indo-Swiss treaty, where part of the MFN clause is triggered without anything else. That means what you call self-operational clause. But the way things have evolved, the word self-operational does not seem to be a correct description, but that's a little later. And the part of this is subject to further negotiations. For example, on the rate side, you immediately lower the rate, but on the scope side, you have further discussion. Possibly, this is for the reason that some more clarity is required about what could be the scope and to avoid the possibility of interpretation, of misinterpretation. The category 1 is a very common kind of a MFN clause in Indo-French treaty, Indo-Dutch treaty, as we saw in Indo-Hungary treaty and countless other treaties. There's nothing further stipulated than the trigger event. And trigger event, as I said, is entering into a treaty with another OECD country. In category 2, all that happens as a result of the trigger event is you get into negotiation. And there's a third category where you do nothing. You just inform the treaty partner country, and then a treaty partner country, and then both of them sit together and review the arrangements. That is, for example, in Indo-Philippines treaty. So it has no immediate impact, just the information to the treaty partner and the review of arrangements. When a treaty partner offers any concession to jurisdiction in respect of certain items, all it does is to inform the treaty partner and go for review. If you look at the Indo-Philippines treaty, you will get that example. Now, just to relate it, because I understand many of you are from non-tax background, just to relate it to day-to-day lives as to how does it really work. For example, you engage a qualified assistant A on a salary X and on Y perquisites. But you assure that employee that, look, I'm employing you today at X salary, but if I engage anybody else on a salary X, on a salary more than salary X, or I engage him on a perquisites more than perquisites Y, then one of these things will happen. And what are those three possibilities? Number 1, I will offer the same terms which I offer to the new person. Number 2, I'll get into negotiation with you to immediately ensure that you are on the same level as the new person. Or 3, I'll keep you informed about it and we'll review this. So these are the three categories of the MFN which can happen. And in this case, it's most favored employee rather than most favored nation. So, but once again, the important thing is there has to be parity growth. You cannot put all kind of qualified assistants in one basket. For example, you might say that, look, I'll only take parity group in those who have qualified in the first attempt, or I'll only take those who have experience in international taxation, or I'll take those who have Big Four background. It may so happen that you may be taking only those who are qualified in the first attempt, but nevertheless, that parity group is identified. Now, the manner, the three categories of the MFN implementation that I have explained, now visualize this in the situation that you are dealing with your employee. You have category 1 where somebody you promise that, look, if I offer someone a better salary than you in the parity group, I will give you the same salary. 2, if I do that, we will sit together and we'll immediately have a meeting and we'll see how to bring you in parity with this. And C, I'll keep you informed about it and then we'll review it, but no commitments. Now, these are this is the same way in which the three groups that we were talking about is three kind of MFN clauses that we were talking about take place. In position 1, nothing further needs to be done. The fact that you have entered into a treaty with the other country offering a better terms and conditions is good enough. And number 2, you get into the negotiations immediately. And number 3, you just inform and agree to review. Now, why do we have the parity group? And what is the role of OECD in this? Before we come to the core decision, it's necessary to understand this aspect. Now, every parity group has to be a neatly defined group. If you are saying, I will not put you in a position worse than anyone else, then you have to say which anyone else. some parity group is drawn up. This parity group, traditionally, in the context of the tax treaties, is OECD members, which is the common thing. It can be universal. It can be anyone. There can be a MFN situation saying, if I have this arrangement with anyone, I'll do it to you. But usually it's OECD member. Now, why do you have the OECD member as the parity group? Now, remember that OECD traditionally was a rich man's club. This was a group of nations which were well-developed nations, which were strong economies, and they were the ones, they were traditionally a homogeneous lot. They were quite kind of a equal kind of persons, equally placed, well-placed, strong economies. But then, as we are all aware, we have seen how Europe has evolved over a period of last particularly 25 years and last quarter century, little more than that, how things have changed, right from Berlin Wall going down, and then their sense of cooperation with each other. Then we saw in 1990 was the first major step which was taken was when they set up the Center for Cooperation with European Economies in Transition. And then the OECD expansion process began, eventually bringing in Czechoslovakia, Hungary, Poland, Mexico, South Korea by 2000. And then it became even more broad-based. There was a report of one Secretary General, Noburu, if I am pronouncing it correctly. And as a result of that report, which was given in 2004, there were more inductions: Chile, Slovenia, Israel, Estonia, Lithuania, Lithuania, Colombia, Costa Rica. So the nature of economies of these jurisdictions became more inclusive, and the homogeny, the factor of being homogeneous was lost. This is the reason why OECD was taken to be parity group over a period of time has been become very, very different. And interestingly, almost all MFN clauses, they began from, I think, 1986 when we had Indo-Canadian, and most of them were in the mid-90s, post-liberalization and pre-liberalization. And those were the days when India badly needed the foreign investment to come, integration of Indian businesses with the global businesses. So normally, when does an MFN clause comes into play? When you're giving an additional assurance. I gave you the example of employee. When you're giving an employee an additional assurance that, look, I'm giving you the salary, but trust me, you are my most favored employee. I won't favor anybody more than this. So I give somebody anything better, I'll give it to you also. Similarly, you are telling your treaty partner that, look, I'm agreeing to have the source taxation of 10%, but if I reduce it for somebody, I'll apply it to through. So it's like an additional assurance. And most of these MFN clauses were in 80s and 90s when India was on the verge of liberalization, and MFN, as we have seen, were in different categories. So that's the backdrop in which you have to understand the MFN clauses came. These MFN clauses were given as an assurance to the treaty partners. They were in 3 different categories, and you will find at different stages those categories were maintained. Now, how does an MFN clause gets triggered? As I said, MFN clause gets triggered by the treaty policy development in the partner jurisdiction after the treaty is concluded. Now, such as subsequent treaties with the other entities in the parity group, or with anyone when no such parity group is contemplated. There are, of course, some exceptions. Usually, it's like saying that, look, I promise that if I do something better to someone in the parity group now onwards, I'll give it to you. But there are situations when the cutoff date is also a retrospective date. The cutoff date is not always prospective. And Indo-French treaty, which is the treaty in covered by the Styria case, is a good example of this. Now remember, this is a treaty which was entered into in September 1992. And the cutoff date was 1st September 1989. So I'm entering into a treaty today, and I'm saying if I have any arrangements in any treaty entered into from back date of 2 years onwards, then I'll give you the same concession. On the face of it, it's very confusing as to why should you not if you have already entered into these arrangements, then why don't you simply put that clause? Why do you give that cutoff date of the earlier period? But I was given an explanation by someone who was closely associated with this particular treaty, and probably the explanation was on these lines, that the date on which the treaty is actually finalized and initialed and approved between the countries is the date which is the prior date. But it gets signed on a much later date because of various other external factors. It could be availability of the honorable ministers, of the dignitaries, some trying to coincide with something else. So when they finalize a treaty and they put the initials to it, they don't want to disturb it. It may get signed 2 years later, doesn't matter, but they won't change even a comma, full stop in that, because once they do it, then it again gets into the whole process of negotiations. So this could possibly be the reason why you have the cutoff date prior to the treaty date, as in the case, for example, of Indo-French Treaty, where in September 1992 you are signing it, and you are taking the cutoff date as 1st September 1989, with the result that a part of the treaty provisions are the provisions which will never see light of the day. Even before the treaty is to be implemented, these provisions are because of a treaty development which has already taken place prior to the date of signing, but after the date of finalization have been subjected to change. Normally, the tax administration issues notifications about the impact of MFN clauses being triggered. For example, if there's a trigger to the MFN clause comes into play, usually the tax administration should, and they do, issue notification saying that, look, this is a trigger which has taken place. As a result of this amendment has taken place. However, there were some judicial rulings, and I was author of one of those judicial rulings in ITC's case, which was later approved by the Honorable High Court, which said that these notifications, being not in strict requirement of the treaty, are nothing more than advisories by way of abundant caution. So these were ignored, and then one proceeded with the judicial forum proceeded with its own interpretation of what should be the correct interpretation of the MFN clause, ignoring them aside, going ahead with this. These things continued for a long time, as I mentioned to you, that from December 2001, when this judgment came, and then the CBDT circular came on 3rd February 2022, which was a long time thereafter, 21 years, almost 21 years, which said that as a domestic law requirement, each treaty amendment, even by what is termed as self-operational MFN clause, needs to be notified to be legally effective. And that's a proposition which now has been upheld by the Supreme Court, and in a short while, we'll go to this, how it has been accepted, what's the methodology that are adopted. But right now, where we stand is that on one extreme, the situation was that if it's a self-operational clause, and I'm using the word self-operational, you can use automatic, but the score is that the only only stated requirement of the MFN being effective is a trigger of entering into another treaty and nothing else. So if there is no such requirement, then this becomes operational when the trigger takes place, when the treaty is entered. That was one school of thought, which held field for almost 21 years or 22 years. Now the other extremists said, no, even though it may not be stated in as many words as to what is the requirement, what is the further requirement apart from the trigger, this is to be modified by the it is to be modified by an amendment to the treaty. Now, what is the trigger to this circular? That's something which we need to take note of. Now, all these years, the issue was with respect to the enforcement of the treaties on things like FTS and other things. There were no inductions to the parity group, which caused the which was the subject matter of MFN clause being invoked. The problem started with a notification issued by Director General of Tax Affairs, International Tax Affairs in Netherlands, and this was, the opening sentence was, the Secretary of State has decided the following, and then it gave an interpretation of their understanding of Slovenia joining the OECD. Their view was that as a result of someone subsequently joining the OECD, that was a situation in which a particular country was not a member of the OECD at the time of entering into the tax treaty, but subsequently joined the tax treaty. When it joined, but subsequently joined the OECD. When it subsequently joined the OECD, the interpretation, administrative interpretation given by the government was that, look, as a result of this country joining the OECD, and since this country has a lower rate for the dividend, participation dividend, that was 5% in that case, now the correct interpretation of the TT protocol is that 5% tax will be chargeable on the participation dividend. That was the interpretation which Netherlands gave. It was immediately followed by the government of Switzerland. Government of Switzerland also gave the same interpretation, but government of Switzerland put a rider to the end of it, which said that if the reciprocity of the interpretation of the MFN clause is not guaranteed by the Indian competent authority, then we reserve the right to reverse the interpretation. So it was like almost like saying that, look, as far as we are concerned, if somebody has to pay dividend to an Indian entity, we'll charge this, but if you don't give us the reciprocal treatment, we'll reverse our stand. And remember, both these countries are the countries which are primarily capital exporting countries. So the kind of dividend flow which you have from these countries to India will be extremely small amounts compared to the other way, the other side of the flow. But when these countries, they announced it, and then government of India took the stand that no, and the exact sentence which was used by the government of India was that unilateral decree, bulletin, publication do not represent the shared understanding of the treaty partners on the applicability of the MFN clause. So what really happened was there was a unilateral interpretation which was in favor of the capital exporting countries, which was announced by two major capital exporting countries, and the government of India said, no, we don't accept this. Now, what is the controversy part of this? Now, two things. Number one, how to give effect to the MFN clause, which becomes operational simply as a result of the trigger event. Is the correct impact of the MFN trigger required to be notified by the central government and the TT concern required to be specifically amended accordingly, or rather the taxpayer can interpret the impact on their own? To go back to the example of the employee which we were mentioning, now what is required to be done? Is a fresh letter to be issued to the employee, or employee can come on his own and claim that, look, this is what you had told me that this will apply. Now give me that salary. You have taken somebody in the parity group at a higher salary, and you had promised to give it to me. So there is hardly anything required now. I am eligible to that. That, of course, these are not valid comparisons for a variety of reasons. There are nuances to these arrangements, but just to simplify for your understanding, particularly those who are from non-international tax background, as to what was the controversy part. Controversy part was, is it required to be amended? Is the TT required to be amended specifically, or is it not required to be amended? Second part was, who should be in the parity group? Is it restricted to those who were originally in the parity group, or will it also extend to those who are subsequently joining the parity group? If you want to have an example of the same kind, probably the example could be, if you are saying somebody from somebody's parity group is required to be of those who are coming from Big Four background, and somebody is working, let's say, XY Desai company, and that XY Desai company gets merged into this later. Now will it come into play, or only those who are already there? But then again, I said these are uncomparable situations. I've given it to simplify this, but these were the controversies. Now, how did the legal battle start? And then we'll come to the what exactly happened and what the judicial decision is. Legal battle started in April 2021 when a Dutch company, Concentrix Services BV, succeeded in a writ petition before the Honorable Delhi High Court on the point that even with respect to those who were subsequently joining the OECD as a part of its expansion process, the protocol clause will come into play. In other words, the protocol clause does not require, in the esteemed views of the Honorable Delhi High Court, that that country with whom better terms are agreed to was originally a member of the OECD when the treaty was entered into. That was a view taken by the Honorable Delhi High Court, a very detailed view, but it was in a writ petition, by the way, so it has not gone into the lower forums, assessment, appeals, SAK appeals, ITAT, everything was on there. Instead of a writ petition was allowed. And in the meantime, something on a parallel note happened was in Hysteria judgment, which has an interesting background, because in Hysteria case was not a case which was directly coming, which was again coming through the appellate channels. That was primarily a ruling given by the Honorable Authority for Advanced Ruling in favor of the tax authority, and that ruling was reversed by the Honorable Delhi High Court, and this ruling was sometime around 2014, if I am right, and then it was reversed by Honorable Delhi High Court. And then, because the stand was once approved by the Authority for Advanced Ruling, and the Authority for Advanced Ruling is very prestigious. It used to be a very prestigious institution headed by a former Supreme Court judge. Then there should be no good reason for the revenue authorities not to take the matter further, even though on the similar point, revenue authorities had accepted the decisions of the tribunal and the matter did not travel further in appeal. So there was nothing in appeal to the best of my knowledge, so far as the normal route was concerned. But against the Honorable Delhi High Court judgment, setting aside the Authority for Advanced Ruling decision, the revenue authorities were also in appeal before the Honorable Supreme Court. And then all these cases were taken up together. Now, what the Honorable Supreme Court has held, so far as subsequent entries to joining the parity group is concerned, their lordships have said that it is clear that expression has a present signification, derives meaning from the context. Given this interpretation, the conclusion is that when a third party country enters into DTAA with India, it should be a member of the OECD for the earlier treaty beneficiary to claim parity. Everything turned on the context, and which is absolutely perfect. Of course, there's a separate debate about static versus ambulatory, and the OECD approach is more towards the ambulatory thing. But when you consider the larger question about the object and purpose, I think the static ambulatory debate becomes irrelevant. There have been many occasions when context is the most important determinative question. So that was the first part of their answer so far as the parity group issue was concerned. Parity group, they said, at the time of entering into the treaty, the tax jurisdiction concerned has to be a member of the OECD. Answer to the main question, which was Nestle's question. And then so far as the second part was concerned, second part was whether you require a notification or not. The way their lordship looked at it was that the mandate of Article 253 is, and it is to be read with entry 14 of 7th schedule, part 1 of the Constitution of India, which deals with the exclusive domain of the Parliament of India on legislation. So it requires a legislative connect to the treaty with the domestic law. And unless that connect is put into practice, the treaty does not become part of the domestic law. So if I could explain that again, the lordships refer to the constitutional scheme of things. In the constitutional scheme of things, a particular reference was made to Article 253. And a particular reference was made to entry 14 in part 1 of the 7th schedule. And 7th schedule, by the way, is an allocation of which part union or the state has the power to legislate upon. Part 1 has the items which are the exclusive domain of the union, that is the parliament. Part 2 is the exclusive domain of the state. And then you have part 3, which is the concurrent list. So at entry 14 in part 1 refers to the implementation of law for making treaties, conventions, international agreements, and to give effect to the decisions taken at the international level. So this was the second part of the answer they gave. Third part was when they referred to the practices. They refer to the practices. Number one, on the academic side, on the academic aspect, they refer to various decisions. Can we have just okay? Just 1 second. Neelam, you can take him out. Neelam, you can take him out. I'm sorry. I have to take a small break because my dog refused to leave. And it's his time for the evening walk. He's more regular than anyone else in the family. Okay. So what was I talking about? Yeah. Two part of the practices. First part was the academic aspect. Academic aspect, their lordships refer to various commentaries as to how the linkage of the domestic law and the treaty list. How the two was, their lordships also refer to the treaty practice. And when we talk of the treaty practices, their lordships refer to what is the exchange of notes, exchange of correspondence between India and its partner countries, and how that practice by itself is a reasonable indicator about how the contact should be taken. So this is how the decision was given. So first and foremost, the most important part of this discussion was with respect to the legislative. Okay, there are two aspects, and both the aspects are quite independent of each other. Now, I would suggest that so far as the taxation of dividends is concerned, on the parity issue, you should be a member of the parity group at what stage? At the stage at which the treaty is entered into, or at the stage at which the treaty is being given effect. By and large, there has been very little questions about this part of the decisions of their lordships. Of course, one can add a lot on the basis of other lines of reasoning also, apart from the short point of the connotations of expression is. And that would be scheme of the treaties. That would be the scheme of the treaty in which, on the basis of which parity is to be given. As I mentioned about the homogeneous lot of the parity group, the relevance of the parity group, and how a subsequent entry may not fulfill the criteria. Take, for example, something very simple. If you have a country from which there's hardly any capital coming, and the question of dividends flowing from India to that country is most unlikely, or even if there's a quantum, it's a very small quantum, then probably the treaty negotiator will be more inclined to give any kind of benefit, because in the real terms, it does not amount to anything. But if the similar treatment is required with respect to a country from where investments are likely to flow to and where the dividends are likely to go, then the approach will not be same. So when it comes to OECD countries, probably their approach would be entirely different from their approach to a situation in which the dividend flow is likely to be low. On this basis, contextually, it makes a lot of sense that you cannot treat that country at parity with a country which was originally an OECD member when the treaty was entered into. On the academic front, on the question of what is right and what is wrong on the first principles, there can hardly be any dispute on that part. Having said that, nevertheless, there was a decision by Honorable Delhi High Court. And of course, even after this decision, there were many people who were not very convinced with the line of, with the school of thought approved by their lordships. And despite the fact that there are lots to gain in terms of the tax outgoes, they did not adopt that approach. Those things apart, it was a reasonable view, but the view taken by the Supreme Court on this aspect, unless somebody has questions to ask, is something which you wouldn't really find fault with. But there's another aspect, and that is the aspect which covers, which is something which is of the much larger ramifications, and which is something which affects everybody. And that aspect is as to the requirement of the notification, even for implementing an MFN clause which has already been entered into. Now, one thing which has happened in this case, and that's very critical, is that these different kind of the MFN clauses, which I explained to you, 3 categories, and they can be technically a 4th category also, in which partly you have the pure trigger and partly you have further negotiations. Partly the trigger is the act of entering into treaty, and partly the trigger is further negotiations. There could be 4th question. This distinction has not been discussed by their lordships at any stage in the judgment. They have proceeded on the basis that all the protocol clauses are to be treated and at par and with the same standard. Now, keep this in mind, and what their lordships have said is that, look, as far as the integration of the tax treaties with the domestic law is concerned, it is only when a treaty is enacted by law or enabled through legislation which assimilates it that such provisions are enforceable in India. And they have said that the treaty is either to be, the treaty concerned has to be legislatively embodied in the law through a separate statute or get assimilated through a legislative device, that is notification in the Gazette based on some enacted law. That is the view taken by the Honorable Supreme Court. And therefore, their lordships have proceeded on the basis that provisions of international agreement, convention, or treaty entered into with India, unless integrated in domestic law through a legislative device, are unenforceable through judicial forums. And in all fairness, that approach finds support from a very eminent tax scholar, the late Professor Klaus Vogel, who has in his oft-quoted book, Klaus Vogel and Double Taxation Conventions, opined that though the mandate of legislature, through the mandate of the legislature, treaties in most states, that's countries, obtain the same authority as internal law. So if you so view this, unless there is a legislative device connecting the treaties with the domestic law, treaties are unenforceable in the courts of law. Based on this, the Honorable Supreme Court came to the conclusion that whatever may be the contents of a MFN clause, unless the impact is notified, and notification is seen as a requirement for that legislative connect to implement the international law or integrate the international law with the domestic law, this cannot be enforced. Once again, I point out that as their lordships came to this conclusion, there was no discussion on what is the import of the treaty of the protocol clauses, MFN clauses being of the different kinds, 3 kinds as we discussed, 4 kinds as a matter we discussed. But then, as it appears to me, there is an alternative approach to this issue also. And one of these decision which has been referred to in the Honorable Supreme Court judgment, in a way, refers to that alternative approach. And that's a very subtle point, but I'll just make it and leave it for you. In the case of Gramophone Company of India, which has been referred to in the Nestle judgment, The problem was that a Singapore-based company had exported some pre-recorded cassettes to Nepal, right? So Nepal as a landlocked country has certain rights under a UN convention that the nearest port, the country with the nearest port has to probably give it a right of way so that it can go through the passage. But in between, the problem came that since there was a violation of the copyright in that on the pre-recorded cassettes, Gramophone Company of India swung into action and they said, no, it's in violation of my copyright, so it cannot be allowed to go here. Then the question arose, to what extent the copyright, the Indian law on the copyrights will get affected by the right to passage that the Nepalese importer has. In this context, the Lordships, Justice O. Chenappa Reddy, and it was a 3-judge bench which discussed it, or the Justice Reddy made some very interesting observations which have been extracted at length in one of the decisions in TII team, and it has also been referred in this judgment. And these observations was something which gives, at least to a layman like me, an understanding that unless the domestic law is contrary to what the international law prescribes, the international law can be integrated with this even without a specific legislative connect. The observations are, there can be no questions that nations must march with the international community, and the municipal law must respect the rules of international law, even as nations respect international opinion. The Committee of Nations requires that rules of international law may be accommodated in the municipal law even without the legislative sanction, provided they do not run into conflict with the acts of parliament. But when they run into the conflict, the integrity of the republic and the supremacy of the constitutive legislature in making the laws may not be subjected to external rules except to the extent legitimately accepted by the constituted legislature themselves. And then they have said national courts will endorse international law, but not if it conflicts with the national law. And the courts are under an obligation with legitimate limits to interpret the municipal law so as to avoid confrontation with the Committee of Nations or the well-established principles of international law. But if a conflict is inevitable, the latter must yield. So what really happens is, if there's a conflict in the law, domestic law and the international law, international law has to make way to the domestic law. No dispute about that. But when they are not in conflict, then the international law must prevail. That is what this decision says. On a similar note, very recently in 2014, in the case of National Legal Service Authority case, their lordships referred to Article 51 to be read along with Article 253. And they said that in the absence of contrary legislation, municipal courts of India would respect the rules of the international law. Now, if you look at this school of thought, it would appear, rightly or wrongly, that the provisions of the international treaties are unenforceable in the Indian courts, even without the express legislative sanction. But then, how does it really matter so far as the income tax treaties are concerned? Because treaties anyway override the domestic law only to the extent they are more favorable, so they have to be in conflict with the domestic law for sure. See, this happens for the reason that if a protocol is already notified along with the treaty, and that has met the test of Article 19, then an implementation of the MFN clause, which is in conformity with a already notified MFN clause, may not be seen as being in the conflict. So to this extent, one could possibly say that there is an alternate theory which is also possible and which some decisions have taken. But then it's on the nuances of the tax laws. We humbly bow to what their lordships have held. And as I say this, may I also point out that Article 253 is, at the end of the day, a part of the chapter 11 of the Constitution of India, which talks about the central-state relations. and specifically on the distribution of the legislative powers. And all it says is that notwithstanding the scheme of allocation of powers, and it says notwithstanding anything in the foregoing provision of chapter, Parliament has to power to make law for whole or any part of the territory of India, or any decision made at the international conference, association, or other body. Therefore, it seems more like an enabling clause. But the lordships have taken this as a need of the legislative connect. To some extent, it would appear that the law, as has been laid down by a 3-judge bench in the case of Gramophone, which has been repeated again in National Legal Service Authority, and the law which has been laid down in the case of the Nestle, is slightly at variance, and probably it reflects a paradigm shift in the treaty provisions being enforced in the Indian courts. But then both the decisions, in all fairness, I must say, which I referred to for the other, advocating about an alternate approach, are the decisions not in the context of the tax treaties. So one has to understand that this discussion is more or less an academic discussion, and we have to accept that the final word has been spoken on the MFN protocol implementation. Of course, it will be interesting to watch how the law evolves on treaty enforceability without the specific legislative connect, whether this departure in the Nestle's case is a permanent departure because of the nuances of the tax treaties, or is it something which may get reviewed at some stage by the other benches, and how will the honorable court see the conflict, whether they'll be able to find a meeting point between these two approaches, or is it something which probably is a little less permanent. Now, the other part of the decision is with respect to the practice part. When they refer to Article 31, they refer to Vienna Convention, a very erudite discussion. They referred about how the practice that we follow also takes shape of the law in a way. Now, their lordships have referred to Article 31(3)(b). And Article 31(3)(b), if you see, this talks about, this is primarily in respect of the how do you decide on the interpretation of the treaties, and how do you find the context? If you look at the Article 31(1) in general terms, it says, it broadly talks about the let me look at it. Yeah. It says a treaty shall be interpreted in good faith in accordance with the ordinary meaning given to the terms of the treaty in their context and in the light of the object and purpose. Now, one of the critical factors is the context. The other critical factor is light of its object and purpose. And third is in accordance with the ordinary meaning, and everything is to be done in good faith. In this context, if you look at subclause 3, it says they shall also be taken into account along with the context, and then B is any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. And it is in this context that their lordships have referred to the fact that there was an exchange of correspondence between India and its treaty partners prior to the issuance of notification implementing the protocol clause, and they have specifically referred to the Canadian example, where this is probably the first what you call self-operational clause. It's a 1986 notified treaty, where in India-Canada treaty there was an MFN protocol clause referring to lowering of the taxes or the scope on a subsequent treaty being entered into by any OECD country, giving better terms or better rate. And then, despite the fact that there was nothing else required, there was an exchange of correspondence between India and Canada prior to the issuance of notification. So that was one fact, and it is taken as a basis which shows the practice. The other fact which has been pointed out is correspondence between India and France. So far as the India and France situation is concerned, I may add, because the India and France has a very unique situation in the sense that the treaty was signed in September 92. Treaty became notified in August 94. And to the best of my memory, the first dispute which traveled to the tribunal reached the tribunal stage in 1998. And I adjudicated upon that dispute in 2001. And remember, in between, the notification came on 10th July 2000. Therefore, to say that until the time notification was issued, there was no dispute, would be a gross understatement. It would appear that on one hand, the persons affected by the MFN protocol non-implementation were content by the fact that they were giving relief through the judicial remedies. And remember, even the appeal which came to the ITAT way back in 1998 was a departmental appeal. I still remember it was Deputy Commissioner of Income Tax versus ITD, 89 ITD 392. So it was a departmental appeal. So apparently some commission appeal gave them relief in 1998 and the notification came in the year 2000. So a parallel exercise was going on at the judicial level. And what the judicial forum decided was that these notifications are issued as a measure of abundant caution. These notifications are not relevant. We don't care about this. And that position remained accepted by and large for 21 years. I would think that it is quite possible that at some stage the SSC was following up with their respective embassies, with their respective diplomatic channels, but then it was not such a critical thing in the sense that SSCs were able to get relief on what they perceived to be self-operational clauses. And there was a school of thought, right or wrong, of course, the benefit of the judgment that we have of the Honorable Supreme Court, it is wrong. But then it was widely held school of thought and a reasonably possible school of thought that these notifications are not required and nothing turns on that. So, so far as the treaty practice of implementing the self-operational MFN clauses is concerned, to my mind, it would be a much better idea, whether you reach the same conclusion or not, to take it along with the judicial development side by side. 94-95 is the first financial year in which the treaty comes into effect. 94-95 is the first financial year for which the litigation takes place. The matter reaches tribunal in 98, and those were the years when the pendency before the tribunal used to be 300,000, as against 30,000 today. It was 10 times of the pendency today. But even then, matter could reach the hearing level prior to the issuance of notification. So, but nevertheless, once their lordships have taken a note of Article 31(3)(b), and based on that, they have come to the conclusion that subsequent tax treaties practices are important, we have to humbly bow to this. There can, of course, be a question whether it is in conflict with Article 26, which requires performance in good faith. But then, just because you have more arguments, that doesn't unsettle the law. Today, you have a law that even to implement an MFN clause, which is self-operational, you need a separate notification. How this law will be perceived, how this law will evolve in the years and decades to come is something to be seen. Now, to sum up, the decision of the Supreme Court, and this is a decision which is very important part, is on the point that you have to have a notification even for implementing a self-operational clause. So in other words, today, whether it's a self-operational clause or it's a negotiated clause, there is no practical difference so far as the taxpayer is concerned. Now, that's the last point I will take before we go to the other things. That creates a situation in which, for implementation of the MFN clause, you have to have an amendment in the treaty. Otherwise, it doesn't work. Now, amendment in the treaty, which is a bilateral act, they say amendment through notification. So, unless that notification is issued, that amendment is said to be not take. It cannot be said to have taken place. Now that amendment is to be issued according to the Supreme Court by the Government of India for the integration process. But one question which has remained unanswered is, what happens if somebody is aggrieved of that implementation? As a taxpayer, I believe that the notification that the government has issued is not in accordance with the MFN clause which was bilaterally agreed to. There is a school of thought, there is a possible interpretation that if you are aggrieved of an action of an executive, unless it falls in the domain of policy making, then, and it is not in conformity with the basic provision, then you can approach the court. But there is another school of thought that you cannot question the government's policy making. A policy making cannot be subject matter of a repetition. Now, if as a result of the MFN clause, the implementation of the MFN clause is an act of policy making, then taxpayer is left with no remedy. You have an MFN clause. MFN clause is interpreted in a way which is less than satisfactory to you, but you have no remedy against it. That's where this is one of the possible interpretations of this judgment. However, the fact that their lordships have given an adjudication on the dividend issue, they have decided against the taxpayer, does not matter. But they have taken a call nevertheless. It does give a ray of hope that at some stage, probably a conscious thought process has to go into as to what is the remedy when a taxpayer is aggrieved of the decision with respect to the implementation of the protocol. Of course, I repeat that, but I cannot hammer that message enough. As long as it's an act of policy making, which invariably treaty making is, then you have no remedy and you have to live with that. But if you treat this as a ministerial act, as an act of implementing the will of the treaty, implementing the mandate of the treaty, then a school of thought does arise that the correctness of the notification, non-issuance of the notification, or delayed issuance of the notification can be subject matter of some dispute redressal mechanism. Looking at the broad scheme of the government functioning, I'm sure every action which is in the domain of implementation and not policy making is something which can be agitated. We have to see it as to how things evolve so far as this aspect is concerned. People talk about it as a unilateral action of the government of India. But may I ask you today, who started it? Unless someone, when government of Netherlands, rather than talking to government of India and finding out a mutually acceptable ground, decided to issue an interpretation on its own, giving a concession for dividends being coming from Netherlands to India, a route which hardly has any traffic, there was no problem at all. So unreasonableness always begets unreasonableness. When you approach things in this way and then people start taking very aggressive positions which are probably not in accordance with the scheme of the treaty, then government is probably not left with many options. So today, as we see all this and we realize the problems that the SSCs are facing, we also have to bear in mind the fact that for a part of this, the blame must be taken by some people other than the government of India, your favorite whipping boy. Now, what's the road ahead? Road ahead, I don't know whether time permits it or not. We already are at 6:33. And so far as the reopening issues are concerned, the issue with respect to the
I think you are in the thick of quite important observations. So please go ahead with that if you find time later on, because
Yes.
time is not, we may spill over by a couple of minutes.
No, I won't take that much of time, but there are few important things. One aspect is the reopening aspect. The other is the period within which the tax withholding demands are concerned. So far as the period within which the tax withholding demands are concerned, if you look at the amendment in section 2013, the amendment which was made for 2013 was with respect to the payments made to the person resident in India. Now, there is a decision by Vizag bench of the tribunal, and they, of course, this is referred to, there are also decisions by Delhi High Court also, which does talk about the fact that this amendment is not applicable so far as the payment made to the non-residents are concerned, with the result that only 4-year time limit will be in operation so far as the payment made to the non-residents are concerned. There is, however, a recent decision, not really recent, it was earlier in 22, shortly before Justice Ujjwal Mehan was elevated to the Honorable Supreme Court in the case of Dr. Reddy Laboratories. That's a very interesting decision, and that interesting decision raises uncertainty about the time also, and that raises that uncertainty about time in a very unique way. The lordships take note of the fact that in some cases 4-year has been accepted, but then what they have observed is that if 7 years is a reasonable time limit for payment made to a resident, so far as the payment made to non-residents are concerned, in respect of which it is even more difficult to recover, the period of limitation cannot be any less. So, indirectly suggesting, directly suggesting that so far as the period of limitation in the 2013 is concerned, that may not apply. That does not apply to the payment of non-residents, but nevertheless, that time limit should be more than or at least equal to the payments made to the residents. As far as people living in the jurisdiction of Honorable Delhi High Court are concerned, they are on a much, that's a much safer place despite all the hazards. As far as the tax position is concerned, you still have the 4-year limit. But for those who are in Andhra or other parts where you have other decisions, then this 4-year versus 7-year is an issue which is likely to be litigated quite a bit. And on a, when we talk of the reasonable approach, I think 7 years makes sense for the non-resident as well. But when we think of the fact that it is not litigated for the non-residents, as on today, there is no time limit. But if you accept what was considered to be reasonable by Mahindra and Mahindra and the special bench decision, then a 4 years should come into play. The other important aspect is with respect to the reopening, and which is what Sachin pointed out to me in our preparatory discussions. That's an interesting thing. If we look at Section 149 and the time limit for issuance of notice, so it is 149(1)(b), where the time limit can be no notice under Section 148 shall be issued for the relevant year if 3 years but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession books or accounts or the other documents or evidences which reveal that income chargeable to tax represented in the form of an asset, expenditure in respect of a transaction or in relation to an event on occasion, or an entry or entries in the books of account which has escaped assessments amounts to or is likely to be 50 lakhs or more. Now the question is that if you have a royalty or an FTS, which you have already disclosed, which is duly taken into account, but today you have a different rate, but today you have a different rate because of the requirement of MFN amendment being notified to make it effective. So instead of 10%, today is 30%. Now, can that fall in the category of 149, 1B, III, and entry or entries in the books of account. If you ask me this question, straight away, the answer seems to be no. That does not seem to be an entry or entries. But then please look at the judicial value system which prevails today. Please look at the way the government, the executive and the judiciary is approaching these issues. These kind of hyper-technical, pedantic interpretations, I don't think are the flavors of the season. So I would suggest that you have to carefully assess the risk appetite of your client before you take a stand which probably tries to save you on the basis of the wording of 149 1B III. That's my quick take in this. As far as the penalties are concerned, I don't think these cases are the fit cases for penalties. There's a reasonable cause. And even if penalties are imposed, there should be a routine thing for getting relief of the penalties. So on the operational side, this is all what I have to add. Sachin, I hope I have not preempted some of your questions. Please feel free to ask.
Before Sachin asks the question, I have one observation. Pramodji, by saying that there is a need for notification, special notification, to bring in the MFN clause, I think the Supreme Court, the Honorable Supreme Court, has put additional burden on the tax department. Because if there is a gap between the tax treaty and notification of the tax treaty and notification of protocol, specific notification, that then there will be unnecessary litigation. So both, in view of the Supreme Court's decision, have to come out as fast as possible. That's my observation on this.
I entirely agree with you. Based on whatever little experience I have, I do not think that everyone in the tax department will be on the same page as with the person who is right. There will be certain areas where there will be some gaps. And my understanding is you cannot have a system which does not have a remedy for a grievance. And if the grievance remedy is writ petition, then we are in for another trouble. It all depends on how you see the act of implementing the MFN clause. In fact, if you look at the penalty made paragraph of the judgment on the second last page, where they mention some words in brackets and they said, and probably negotiation. I think that holds the key. If these notifications are to be done post-negotiation, then these are out of the ambit of the writ jurisdiction. These are the bilateral decisions. And you cannot question a bilateral decision in a court of law. So that is over. Of course, it gives greater certainty in the sense that both the TT partner jurisdictions are on the same page. They have at least agreed with each other on that interpretation. But then, as I said, unanswered question to me is then what is the distinction between these different type of protocols? If you wanted a negotiation, you could have said it. I think the only difference is that when these MFN clauses were entered, India was in a little deeper in the woods, and we were just taking them out. Today we are in a position we can assert ourselves, and we can be more forceful, whether it's appropriate or not. And then the kind of approach which was adopted by the taxpayers also was less than satisfactory. The kind of approach which was adopted by some of the governments by offering concessions of those clauses, which were totally illusory concessions. How many dividends are coming, from Netherlands to India? But that concession was given as if they're on the parallel level. And who would know it better than you, Mr. Singh, as a TT negotiator, that the perceptions of the capital exporting countries and capital importing countries cannot be the same. And there's no need for us to, thrust ourselves on each other. There could have been a more open dialogue.
Yes. Yes, Sachin.
Yeah. Thank you so much, sir. And since we have already covered or touched upon the very important topic of 148 and 149 notice and 201 under bracket 3, because these are, I think, most of the practitioners who are dealing with 147 notices, they may face such type of notice also. Because I don't know, but in future department may come out with a view that since it is a escapement of income in any, although it is not falling under any of the category of 123 of 149, but it may so happen that in future they may come out with such type of notices, and the SSC has to respond on that notice.
Sachin, one has to be realistic. Today you can't, today the kind of ecosystem that you have,
Yes, sir.
you can't really cover yourself with these kind of excuses that if you are, comma full stop, things don't work. And the judicial value system has undergone a very, very significant change. We have seen how the system has, judicial system has changed over the last 1 decade or so. I don't think this is a very safe approach to look at the wordings of the particular section and based on an interpretation which you are yourself not convinced with, try to cover the SSC. But nevertheless, risk appetites differ from SSC to SSC and consultant to consultant. So it's their call.
Sir, if you refer to section 910(2), which says that the provision of the agreement or the provision of the act shall apply to the extent they are more beneficial to the SSC. And now, since the protocol is the part of the agreement, and through this MFN clause, the SSC is going to get the beneficial provision. But now it is saying that the notification is required. Since already it is already in section 910(2) that the benefit will be given to the SSC, whichever is beneficial to the SSC. And it is already mentioned that the protocol is part of the treaty. Then do you really feel that the further notification is required? And the second question is in the same line, that what if that there is time gap of issuing the notification? So what would be the position in between?
So far as first question is concerned, Sachin, you should remember that section 90 subsection 2 was brought in a different context. That was in the context that at some stage the interpretation, prior to 90 subsection 2, we had a circular 333, which said the treaty, which gave the broad provision. But then some departmental officers started taking the stand that now that you have a treaty, the provisions of Income Tax Act have no application. So, this was 90 subsection 2 was brought in to address that issue. If you look at the memorandum, it was 1991 or 89 perhaps, where they have mentioned it. They have clarified that aspect, that even though you have a treaty, to the extent the provisions of the act are beneficial, this will apply. So far as the question of the treaty override is concerned, 90 subsection 1 clearly says that once a treaty is entered into and it is duly notified, it becomes part of the law. Now, that is the reason I was pointing out that paradigm issue with respect to conflict with the domestic law. If you have a treaty and you have a protocol, and interestingly, for example, in French protocol, it is notified on the same day along with the treaty itself. And the protocol also says that it shall form integral part of the treaty. Now, if you have a treaty and a protocol which is duly notified under section 90, subsection 1, then implementation of that cannot be said to be in conflict with the domestic law. And therefore, following the theory that even without the legislative connect, the international treaties can be enforced. The theory which is approved by, in the case of Gramov, in the case of National Legal Service Authority, that was regarding, I don't remember the respondent's name, but the petitioner was National Legal Service Authority. In both these cases, as a matter of fact, in the National Legal Service Authority, their lordships have said, they have referred to Article 51. They have said Article 51 read along with Article 253. So they don't treat it as a mandate of law to legislate for the treaty. There are two ways. One, when you treat 253 as an obligation to legislate because you have a treaty. The other way is when Article 51 you treat as a mandate to enforce the treaty, and 253 gives you the right, exclusive right to the parliament to legislate on that aspect. So if you follow this theory, then probably notification is not required. If you follow the theory that once a notification is issued, the protocol and treaty become part of the domestic law, then the implementation of domestic law, even if it varies from that provision, is not in conflict with the domestic law, and therefore it is applicable without it is enforceable without the legislative connect also. Then it is not required. However, today, in the context of the tax treaties, their lordships have categorically held that a legislative connect is required. And they have said so even after taking note of the fact that Income Tax Act already provides that legislative connect in Section 90, subsection 1. They have also referred to another act, Extradition Act, where you have an existing connect. They have segregated into two categories. So one category when you have the existing connect in the Enabling Act, and the other where you have no connect. In the second category, you have to make law for this. In the first category, law is there, just issue a notification for this. So as the law stands, what I personally feel, what you personally feel is irrelevant. We bask in the glory of one of the most independent and efficient judicial system in the world. So if you bask in that glory, you also have to live with the limitations, systemic limitations of having some decisions which may not be to your pleasure, which may be slightly at variance with what an academician would say. But we have to live with this. It's a part of package deal.
Right, sir. Sir, in your deliberation, although you have already covered that in respect of India-France treaty, since there are various dates are given, like the date of signing, the date of applicability, and in case of protocol and the MFN clause, it says that it will be applicable to the retrospective date, or I can say that from 1st of August, 1st of September 1989. And after this, India-US treaty comes in that on 13th or 12th of September 1989. So does it make any relevance? Because since your treaty is signing on the latter date and the benefit is being given from the retrospective date, so does it what is the purpose of this, sir?
I don't know whether Mr. SP Singh would like to answer that in public.
Look here, this whole treaty negotiation happens in several stages. The first stage is completion of negotiation by the tax authorities, and then it goes to the parliament and goes to the ministries and get approved in India. Whereas in other countries, and France being one of them, it has to be approved by the parliament and before it comes into force, and that takes a lot of time. So many a time, when the negotiation is going on, the date is put in that context, whereas the actual signing or actual notification may be on a subsequent date. That is why you see 3 dates in respect of France.
Yes, sir.
But it's difficult to believe that once all I's are dotted, all T's are crossed, then you wait for 2.5 years to sign the treaty. This looks very strange, but then your experience is much.
Many a time, Pramodji, this happens because of the legal process in the other country. In India, we don't wait long, because moment the officials negotiate, it is circulated only among the ministries' approval, and then in that case it is ready for the signing. But in other countries, they have to undergo different mechanism of getting approval, and that may tie or might have taken time in other countries.
I would still think there have to be some, there could be some other factors also, because remember, if we apply the same theory to the Indo-US treaty, and Indo-US treaty was one of the treaties which took long time to be finalized. Indo-US treaty was signed on 12 September 89, and therefore I suspect that it must be ready for signatures, let's say in 87, 88, or sometime if it takes so long to sign. So in 89, which you say is the cutoff date, which is given 1st September 89, they would at least be aware of what's going to happen in the Indo-US treaty. It looks very, to be honest, one doesn't really get answers to this. One probably reason could be that if they admit it, then they will be divulging the Indo-US treaty, which is not in public domain, which is equally not possible. Therefore, what you say seems to be correct, that the long time gap between finalizing a treaty and finding a suitable muhurat for its signing. Suitable muhurat means right people coming in, all those paraphernalia being completed. all the process being completed. This could be the reason. I was also surprised by this. As a matter of fact, on my LinkedIn page, I once wrote, if somebody has a clue, please share. But it was only after I had the benefit of talking to Singh Saab that we could get that insight, interesting insight into the treaty making process.
Thank you, sir. So, one more question. So, while referring to India-Switzerland treaty, in the protocol which is mentioned that the Switzerland and India shall enter into negotiation without undue delay in order to provide the same treatment to Switzerland and India provided in third state. So, this is relating to protocol. So, when they say that enter into negotiation, so is it since it is already negotiated and it is already said that the benefit shall be given if you enter into the beneficial provision with the third state, then whether the further negotiation is required or what is the intent behind this, sir?
If you look at the Indo-Swiss treaty, even the negotiation part, if I remember correctly, is with respect to the scope of services, not on the rate aspect.
Yes,
rate
sir.
aspect negotiation is not mentioned, it's only on the scope. But the problem starts because people, sometimes the perception about the scope could vary depending on some people picking up only a sentence from one place and a sentence from another. I think that's an area where more the greater clarity is required to be given, and that must be the reason, and that's a good reason for the policymakers in the CBDT to put the implementation or notification of the scope on hold unless there's complete clarity and there's no ambiguity on that side. But then, as I said, these are the factors which is why the self-operational clause comes into greater discussion. In some areas, you have recommended negotiation. Some area you do not have.
Yes, sir.
The mistakes, if at all, which were committed, and these are not mistakes. Hindsight is the only exact science in the world. Once after the event, everybody is wiser. Today, today CBDT officials may realize how unreasonable a taxpayer could be how unrealistic or unreasonable approach one may have adopted. But when you are entering the treaty, getting into that agreements, these things may not be visualized as to what could be the difficult areas. Who could have visualized that there will be subsequent expansion of the OECD, and then the issues would arise whether the people who are not OECD members today would become OECD members tomorrow, and what will happen. So hindsight only gives us all these benefits that are about knowing what's going wrong. So as it appears to me, undoubtedly, the judgment and the approach of the CBDT is undoubtedly little harsh on the mandatory notification required on the self-operational clauses. But then I think there were circumstances and there were kind of interpretations which required these extreme steps. I'm not saying for the legislature, for the judiciary, I'm talking with CBDT. Because when you talk to them, when you understand their side of the story, when you realize what kind of unreasonable approach is adopted by very creative, aggressive and very creative process of interpretation and picking up parts of the scope, picking up a sentence from the whole paragraph, and then trying to interpret this on the basis of that sentence. And then we are living in a system where everything is not subject to the scrutiny. You have very limited cases which are being scrutinized. So the CBDT has all the more reason to be more careful by taking a macro view and ensuring those leakages do not take place. For every case caught, there are 1,000 other cases which the same mischief maker is not caught.
Yes, sir. Sir, there are many questions from the participant also, but due to paucity of time, we'll take one more question and then we'll come back to Piyush sir for concluding remark. So one question which is we received from the participant: what happens to the past cases where the relief has been granted to the taxpayer even when a notification were issued much later? So already settled cases. So SSC has got the relief, department has assessed the case, and everything is closed now.
That's why you were talking about the reopening.
Yes, sir.
Okay, so and ultimately, so for the judicial, if the matters are under litigation, then of course now we have an authoritative clarity from the Supreme Court that decision is to be implemented. The only curiosity people have is whether there can be litigation on the question of correctness of the interpretation or not. That's little curiosity left as to how things will be taking shape. We have also already talked about the reopening possibilities. The cases which can be reopened will be reopened. Where these can be, if they have got relief and these decisions can be subject matter for rectification, those rectifications will be done within those time frames which are permissible. Then further litigation, then of course they have nothing to gain. That's how it is.
Thank you so much, sir. Now I come to you, sir, for the concluding remark. And thank you, SP sir, and thank you, Pramod sir. Thank you so much.
Thank you.
Thank you. Thank you very much, Sachin ji. Thank you very much, Pramod Kumar ji, SP Singh sir, for a wonderful discussion we had. Of course, our discussion has not only been restricted to Supreme Court judgment, but I know we have covered immensely all the tax treaties, the way the tax treaties have been negotiated, and obviously the participants have been benefited by both the speakers who are from a different aspects, who have been on a judicial side and one who has been on the government side. So it has been a very wonderful discussion. I really thank you all, the speakers, especially Pramod Kumarji for sparing his time, and SP Singh Saab, who always, as I said, is always available for DTC. Sachin ji for a wonderful moderation and raising questions. I know. Just for the information of all the speakers, total we had around 1,300 registrations today, which speaks about the volume of the. Of course, a lot of people would not be into the international taxation, but a lot of our practicing chartered accountants look forward to learn international taxation, come into this area, and excel in this particular area. The way the India is moving, way the cross-border transactions are moving, way the Indian entities are going global, I'm sure it's a huge opportunity for the Indian practicing chartered accountants. So I would request all the participants, please be in, please watch for this fortnightly webinars which we are doing on the direct tax side also, and all the international tax side also. I'm sure you all would be benefited. So very good evening to all of you, and good night. Thank you very much. Thank you once again to all the speakers, Pramod ji, Singh Saab, and Sachin ji. Thank you. Tag team, we can stop the recording and close the session.